Hello everyone, and guess where I am today? I'm at Leeds, specifically at University of Leeds. Check out my surrounding view, isn't it just beautiful? The weather today is 4 degrees Celsius and School of Law is just right there. It's about 5 minutes walk from where I'm standing today. So for this lesson, we'll be learning on the topic of tribunal. It's one a very interesting topic and is usually covered in the examination questions. So when we come about alternative dispute resolution, it is very important for students to familiarize themselves with the area of tribunals, mediation, as well as arbitration. Because for the purpose of English legal system, you need to cover this area of law: tribunal, mediation, and arbitration. So for today's presentation, we'll be learning about what is tribunal and the application of tribunal itself. So what is tribunal? So as all of you know, whenever there is a dispute between two individuals or more, uh, the famous decision that parties will take is to go to court. Whereas tribunals can be considered as an exclusive judicial body whereby parties can opt to go for a tribunal, get their matters heard by specialists, and get the outcome that justified for both parties. So when it comes to the definition itself, because the word of tribunal has a very long history, those days it's very difficult to ascertain a particular meaning. But nowadays, you can just refer to any definition of tribunal. When we talk about tribunal, it is actually a body that was designed by a legislation. So you need to have a legislation, for example, with regards to Employment Act, for example, and in that act, there will be a provision or section that states that a tribunal will be established in order to resolve dispute between employer and employees. Let's say for husband and wife, because in the Family Act, there is no provision that specify parties need to go for tribunal or tribunal needs to establish. So which means with regards to divorce cases, they don't go to tribunal. So you need to first understand the concept of tribunal. It exists when in legislation specified the establishment of a tribunal. So the features of a tribunal, they are essentially like courts because you have a panel, you have a claimant, you have a respondent. But they are not courts because for courts, any parties can just go to courts and make a claim, whereas tribunals, they are dedicated places that hear very specialized matter in order to resolve legal dispute. They are very specialized because the panel members have many years of experience dealing in that particular matter. It's essentially an informal bodies because they don't have a sitting like courtroom, and it's very flexible in terms of where the parties can resolve the dispute. It usually takes place in a meeting room or in a office building, not necessarily in a courtroom. So I gave an example when we talk about tribunals, employer and employee. So you have employment tribunal, but there is an extensive list of tribunals that exist in UK. For example, concerns tax, financial services, asylum, land, transport, anything actually, as long as there is a legislation that specifies the establishment of tribunal in these particular areas. So for the purpose of examination, you don't have to remember the list of tribunals because it's not necessary, but it's good that you familiarize in the aspect where tribunals can exist. So when I talk about legislation, this is an example of the creation of tribunal. First, you need a legislation, an act, which states that Employment Tribunal Act or a tribunal will be established. So in the legislation, it talks about the appointment of tribunal judges, and the membership of the tribunals is not necessarily need someone who's an expert in the area of law. It can consist of a judge who sits as a chairperson, the one that leads the session, and it can also be two non-legally qualified members. So not necessarily members of the public, but it should be someone, like for example, that used to work in a human resource department for 10 years, someone who's very specialized or known about the procedure and processes with regards to workplace, then can sit as members of a tribunal. So tribunal members are usually appointed by Lord Chancellor, but the issue arises, what are the problems with the tribunals itself? So there is a problem there when it comes to the appointment by Lord Chancellor. So it's a good area that you read up and do homework because you'll be asked in the classroom itself. So these are the points for your ease of reference when it comes to tribunals and courts. So when we talk about tribunals, there are a presence of non-legally qualified members, so not necessarily someone who has studied law and be admitted to the bar, whereas courts, for judges, you need to have an experience as a barrister or solicitor for a certain number of years and then can make an application to become a judge. So it's much cheaper going to tribunals instead of going to courts. Accessible to everyone. It's freedom from technicalities. Basically means that parties are not bound by the rules of courts. So parties not necessarily need to have a lawyer to represent them. The person can represent themselves in the tribunal session itself. So it's very fast. The matter can be deliberated as fast as 1 day, and it will be deliberated or it will be decided by someone who has an expert knowledge on that particular area in dispute. For example, tax, land, transport, etc. So this is one example of employment tribunal case, because employment tribunal case is separate from court, so you won't be able to find out or read up a lot of tribunal cases on LexisNexis or Westlaw. There are vast cases when it talks about tribunals, so it's just good for you to at least familiarize with one example of a tribunal case. So this is the recent case when it comes to tribunal, where Uber wants to take an action against Aslam and others. So this is an appeal case. So you won't be able to, because as you can see here, it deals with the Court of Appeal case. This is one example. And the matters will be deliberated in the tribunal. So these are the procedures when it comes to making a claim on the employment tribunal. So parties will make an application either by post or online, and then you follow the rest of the steps. So it is very important for students to familiarize with the steps, because sometimes in the examination, question will be asked with regards to what are the procedures for parties to make a claim under employment tribunal. So it's good that you can remember all these steps and how the judgment will be issued, and is there any alternative where you can appeal to the decision made by the tribunal members. So what are the problems of having tribunals? So there are problems, and it was identified back since 1957. I started off with Frank Committee, investigated with the workings of the tribunals. In the earlier slides, you can see the establishment of various number of tribunals. And because there are so many tribunals established by different legislation, so sometimes the processes varies or different from one tribunal to another. So how you make a claim in employment tribunal case is different from tax matters, for example. So that's why the committee was set up, and it was chaired by Sir Oliver Franks, because there was a concern about the range and diversity of tribunals. So each tribunals, they are making their own processes, they work in silos, they don't communicate, so it becomes difficult for the members of the public. So because of that, investigation was done. But even though investigation was done, in 1980s, the committee put for a report asking for further powers, but this was not granted. So over the years, up until 2001, the government then asked Sir Andrew Leggett to look again at the tribunal services and see what are the areas of improvement can be done. So they review the funding, management, structure, essentially everything. So the report was followed by a consultation paper and a white paper called Transforming Public Services, Complaint Redress and Tribunals. So the report was published in 2001, and in the report it was identified that there were 70 different tribunals in England, and the quality varies from one tribunal to another. One can be super good, excellent and outstanding services, whereas one, it can be all over the place, or it can be considered as inadequate. So because of that, the report identified the weaknesses, and there was a concern that tribunals were not accessible by the members of the public. Hence, it defeats the purpose, because public supposed to opt for alternative dispute resolution instead of going to court. So these are the list of recommendation established by Sir Andrew Leggett and his team in 2001. So the proposed recommendations were independence from the ministry or sponsoring departments, so that the tribunal will appear to be neutral and independent. Uh, Tribunals to exercise the jurisdiction suitable for the area, and simple procedures, effective decision making, and cost effective. So finally, in 2007, Tribunals Court and Enforcement Act was enacted. So in terms of legislation, this established two types of tribunal. You have first tier tribunals, and if you're not happy with the first tier tribunals, you can appeal to the upper tribunal. So because of this, it becomes more structured. So as you can see, these are the example of structure of tribunals in United Kingdom. So that's all. It's pretty easy, but sometimes students do find it a bit confusing. So please read up on the area of tribunal so that you'll be able to distinguish tribunal from mediation and from arbitration. Thank you.